Good morning and welcome to the 14th meeting of 2025 in Session 6 of the Equalities, Human Rights and Civil Justice Committee. We have received apologies this morning from Maggie Chapman, and we have Paul O'Kane and Tess White joining us remotely. Our first agenda item is to take agenda item 3 in private. Agenda item 3 is an opportunity for the committee to consider its annual report. Are we all agreed to take agenda item 3 in private? We are agreed, thank you. Our second agenda item this morning is to continue evidence taking on our civil legal aid inquiry. In this inquiry, the committee is exploring what is working and what is not working within the current legal aid system, and what changes could be made in the shorter and longer term to address issues around the access to civil legal aid. I therefore refer members to papers 1 and 2 and welcome the first of two panels this morning. We will firstly hear from the Scottish Legal Aid Board. We have Colin Lancaster, Chief Executive, and Marie-Louise Fox, Director of Strategic Development, Scottish Legal Aid Board. You're both very welcome this morning, and I would now like to invite Colin to give us an opening statement, please.
Good morning. Thank you, Convener. Thank you very much for welcoming us along to give evidence this morning. I think this is an important and timely inquiry. The committee has heard from a number of witnesses already and received a number of submissions, which I think highlighted a number of challenges in the current legal aid system, but also pointed towards some opportunities for positive development. I think from Scottish Legal Aid Board's point of view, we would say that the legal aid system has several quite significant strengths, but also a number of challenges. Some of those challenges are inherent in the structure of what we call a Judicare system, where individual payments are made in relation to specific cases, and as such, the system is reactive. It's not planned. There are very few mechanisms within the system to direct resources towards particular areas of need, whether those are parts of the country, particular communities or client groups or types of cases. The pattern that we see in terms of expenditure and the delivery of services is largely demand-led, but also determined to a large extent by the decisions of individual practitioners and firms up and down the country as to which cases they will take on, what subjects they will cover, what volume of business they will undertake. And as a result, it can be very hard to predict what services will be available in any given place or time, or to know that supply will be available on the ground if different needs emerge. We think there are definitely opportunities to address some of the, if you like, the challenges in the operation of that Judicare system. The committee has heard a lot about a number of those issues. There is some scope for change on SLAB's part. We can look at the areas of the system where the legislation gives us discretion, but large parts of the system are very tightly defined by regulations and primary legislation. And our view is strongly that we need a new statutory structure for the legal aid system, both to enable the Judicare system to work more effectively, but also to shift the emphasis towards that more strategic, proactive, needs-focused approach, which would enable the system to maybe be reorientated and allow services to be designed and delivered with user needs in mind and in anticipation of user needs, as I say, in relation to different types of cases and different parts of the country.
Thank you. We're now going to move on to questions, and I'm going to kick us off. The witnesses that we've had so far at the inquiry have all indicated that they would like to see a significant increase in investment in legal aid. Why does the Scottish Legal Aid Board not think that fee increases are enough to deal with the issues that we face in the civil legal aid system at the moment?
I think there are a number of ways in which one can invest in the system. Our comments in our submission were really about whether fee increases alone could address all of the challenges that are set out elsewhere in our submission and that we've heard about, and the committee's heard about in the other submissions and the evidence that's been provided. Resources is a constant challenge in any public service environment, and it seems obvious to say that additional resources could lead to improvements in service delivery or availability. But the particular mechanism of increasing fee rates doesn't in and of itself guarantee or secure any additional service delivery. There is a risk that we simply pay more for what we're already getting, and that we don't actually get any increase in supply, any increase in accessibility or in service delivery. And that's because of what I just described, the reactive nature of the system. So yes, more solicitors might, if fees were increased substantially and the work became more financially attractive for solicitors, more solicitors might choose to enter the legal aid system. They might choose to do more work under legal aid as opposed to privately funded work. But there's no guarantee. They might not. So the increased investment there might not actually secure any additional services. Other mechanisms for investing in solicitor services could include the provision of grants or entering into contracts to provide specific services in specific places. And it seems to us that that is a mechanism that would better align with any particular goals that we, the government, the Parliament, might have in relation to increasing accessibility and availability of services.
So do you think that fee increases shouldn't happen, or do you think they should happen along with other structure changes?
It's not for us to say whether they should or shouldn't. Those are decisions for government. The fees that we pay are set out in fees tables, and those fees tables are incorporated into the regulations that ministers introduce and the Parliament considers and passes. So those are decisions for government. What we would say is that if the aim of increasing fees is to address identified issues, that might suggest a targeted increase, so specific types of activity being paid at higher rates or different rates, or looking at whether there are, I think our sense, and looking at the data on activity, our sense is that the profession views certain areas of work as more profitable than other areas of work. So that might suggest that you would look at those less profitable areas and target fee increases on those areas of work rather than those across the board percentage increases, if you like, where the impact may well be very diffuse.
Okay, no, thank you. It's helpful to know your opinion on that. We're now going to move to questions from Evelyn Tweed, please.
Thank you, Convener, and good morning to the panel, and thanks for your answers so far and your opening statement. Witnesses have highlighted to us recruitment and retention issues for solicitors working in civil legal assistance. What is the Scottish Legal Aid Board doing to address this issue?
That's a very interesting question. Thank you for that. Yes, we're aware of the various comments that the profession have made for many years now in relation to the numbers of solicitors in the sector, the number of solicitors coming into the sector. We've recently published information about activity levels in civil legal assistance, and that shows that there are lots of different things happening in the sector. We don't actually have overarching data about the number of solicitors or the extent to which they are involved in legal aid work. We don't hold data about the demographics of the solicitor profession as a whole, or those who are providing legal aid services within that. So it's very difficult for us to make any broad statements about what's happening within the sector. I think that the point about recruitment and retention and what we're doing about it is a particularly interesting question, because the nature of the system means that we actually have very few, if any, levers to influence either current or future levels of supply. It's not a system where anybody can engage in workforce planning the legal aid workforce, if you like, are individual solicitors in predominantly private businesses, making choices on a day-to-day basis or a year-to-year basis about their level of involvement in the legal aid system, if any. So there are few opportunities to look at the profession as a whole and influence the number of solicitors who are undertaking legal aid work. Where we do have a role is in relation to our own employed solicitors. And we've been doing some work over recent years to try and encourage more people into predominantly social welfare and criminal law by looking at our own structure. We employ a number of solicitors in Public Defence Solicitor's Office on the criminal side and the Civil Legal Assistance Office on the civil side. Those are small numbers relative to the size of the profession as a whole and the legal aid sector as a whole. But we are looking at work with schools, with universities, by offering paid internships, shadowing opportunities, and most recently a combined traineeship, where we've taken on this year 3 trainees to work across our Civil Legal Assistance Office and PDSO, so that they get a range of exposure to different types of legal aid work. And our aim from all of that work, taken in general, is to encourage people to see legal aid as an attractive area of work, and to open up career options within our service, but also to equip people to go on to work in private practice or in third sector organisations. But as I say, those are very much kind of at the margins, because the total number of solicitors that we employ is a fraction of the total number of solicitors providing legal aid, and we don't have those levers in relation to that wider pool.
And you say there's issues with the data and the levers, and you're talking about quite small numbers for your own, the things that you're trying to do yourself. But given a lot more is needed, do you have any thoughts on how that can be provided if you can't do it?
There have been discussions with the legal profession through the Future of the Legal Profession Working Group, which was jointly convened by the Minister, the Faculty of Advocates and the Law Society of Scotland. And it explored a range of issues to do with recruitment, retention and diversity within the legal sector more widely. So although some of the discussions focused on legal aid, it was a wider working group. And I think what was striking there was that a number of the issues that were identified were common to the legal profession generally. So they go far beyond the legal aid sector. And that might mean that there are particular challenges facing small firms. The Law Society is currently undertaking research with small firms to explore some of those challenges. There might be issues outside the central belt, particularly in rural areas, of attracting newly qualified solicitors to move into those parts of the country. And I think, again, the evidence that was brought to that working group from across the profession suggests that there are work-life balance issues, and that the career expectations and aspirations have shifted. The models of employment, the models of working, the sense of going into a firm and staying there until you become a partner and staying there for your entire career, those seem to be shifting, and those impacts that are felt across the legal profession will also be impacting upon legal aid, because the vast majority of legal aid firms are small, many 2 or 3 solicitor firms. So the types of challenges that they face will be common to the sorts of challenges that are faced by other small firms more widely. So that suggests a range of responses profession-wide, maybe looking at some of those education pathways, what can be done within universities to encourage different types of work. And I'll be fascinated to see what the society gathers from small firms about their views on the challenges they face and their suggestions for any interventions that might be made at a national or local level to address those.
Now questions from Pam Gossel, please.
Thank you, Convener, and good morning, panel, and thank you for the information you've provided so far. Witnesses from the past 2 weeks have called for financial eligibility criteria to be expanded, as financial thresholds have not been updated in line with inflation since 2011, which was 14 years ago. Modelling from the Scottish Legal Aid Board shows that eligibility for civil legal assistance has decreased, and that it may be becoming a barrier in relation to advice and assistance. At the same time, those who are eligible for legal aid struggle finding solicitors that would take up their cases. Over the last 2 weeks, we have heard evidence which has echoed this. Whilst the Equalities Minister told the Social Justice Committee that legal aid needs to be reformed, nothing has happened. Do you think that the Scottish Government is failing the most vulnerable in our society? And what more do you think needs to be done? And I'll go to you, Colin.
Okay. Thank you. There's quite a lot in that question. I think the point about eligibility is an important one. We highlighted in our own evidence those changes that have happened over time, and you're absolutely right that the limits have not been increased for some time. They were originally frozen as part of the response to the economic downturn. And as you say, that's now 14 years ago, and as a result there will have been a gradual drift out of eligibility for some people. I think the key issue, the one that's been flagged, is perhaps the low capital limit in relation to advice and assistance. It's significantly lower than the civil legal aid limit, around £1,700, and unlike with civil legal aid, it is a fixed limit. The tests for advice and assistance are far more, if you like, clear-cut and fixed in the regulations. So there's very little room for the application of discretion on those. I think again, looking over decades, the ways in which advice and assistance is used have changed. When it was introduced in the 70s, it was intended to be a short, sharp piece of advice. That initial advice from a solicitor, but I think what we've seen over the years is that it's evolved into a precursor to litigation in some cases, but an alternative to litigation in others. So you can find fairly extensive, if you like, negotiations or pre-litigation procedures taking place, which costs far more than the original short, sharp half-hour. It was colloquially known as the half-hour scheme. And a low capital limit might have been appropriate for that one-off piece of advice. It's maybe less appropriate for what is in effect full casework. So I think that potentially poses a barrier, particularly for those who go through that process and then need to go on to litigation, because in many ways advice and assistance might be a gateway into further legal aid. So I think there is a potential challenge there. On eligibility more widely, we've been doing quite a lot of work, as well as analysing the population that's eligible, looking at the way the different parts of the eligibility system operate. And I don't know, Marie-Louise, you might want to say something more about what we've been doing there.
Sure. Yeah. Thanks. Thanks very much for the question. Financial eligibility is something that we've been looking at for quite a while. So the proposal that we consulted on was to look at financial eligibility in civil legal aid, and to look at making it a simpler process, making it a more transparent process, making it easier for people to understand what it is that we would take into consideration, and what information they would need to provide to us. So we looked at different ways in which different parts of the public sector, when they have to do any kind of means assessment, what are the standards that they use? What are the factors that they take into consideration? So particularly in legal aid, as I'm sure we'll touch on quite a few times today, the Act and regulations really do tie down quite a bit the test that we have to apply, and in particular for civil legal aid, sets out how we need to assess financial eligibility. But it also does provide us with quite a bit of discretion. So this is why we looked at this area, because we could do things by looking at our policies and how we exercise our discretion that the legislation does give us. And looking at a range of standardised allowances could help make the system simpler. So we have to try to calculate a person's disposable income. So we need to look at all the range of income that they have and all the levels of expenditure that they have. And that requires us then to go into quite a lot of detail with that person, and they need to provide us with quite a lot of verification. And you've asked questions about that and heard evidence about that. That system provides a very bespoke and highly individualised assessment. So in some ways, some people would say that's actually quite a fair system. But on the other side of it, and given the points that you've made previously, it's a very, some people would see that as a kind of interrogating them about their personal circumstances. So we looked at other ways in which public bodies provide allowances for what is the cost of living. So instead of us having to ask somebody about all their expenditure, are there public bodies who allocate allowances that represent a fair cost of living allowance to everybody? So that's what we consulted on, and we've been doing some very detailed work. We're selecting a system that's used by different government departments and local authorities where means testing is needed to put in place standardised allowances for individuals, for their partners, for any dependent children, but also importantly whether there's other factors such as disability. So we're coming to the end of that work and developing the policy on that, and that's something that we will be going out to public consultation again to say this is, after the initial consultation, this is what we've ended up with, and this is what we think could make the system more transparent and simple, easier to understand for people.
Thank you, Marie. That's really helpful. My next question kind of goes in a little bit into that means testing. Witnesses that attended this committee over the past 2 weeks have called for the removal of financial eligibility requirements for certain types of work, including domestic abuse. Survivors of domestic abuse, the majority of which are women, are some of the most vulnerable members of our society. This is an area I know extremely well, as I have introduced my own Prevention of Domestic Abuse Scotland bill, and many of the survivors I've spoken to have told me how their abusers controlled their finances. Many of these women do not even know what their household incomes are. Last week we heard the legal aid for housing in England is not means tested. Do you agree we should take this as an example and apply to legal aid for domestic abuse in Scotland? And also touching on that, Marie, you've talked about a consultation you've put out, obviously, on means testing. Is there anything round this, any work that you've done round this? And when will that consultation, the information, be available? So
we'll be consulting on that this year. Yeah, so fairly shortly. Yeah. Do you want to say the word?
Yeah, and as Marie says, that consultation and the further development work follows on from a consultation we did a couple of years ago, and Women's Aid responded to that consultation and provided quite a lot of feedback on the kind of dynamics of finances that you talked about there in abusive relationships. We've been quite struck in some of the evidence that's been provided, and you mentioned the Minister for Equalities at the Social Justice and Social Security Committee. Myself and a colleague gave evidence there a couple of weeks ago as well in relation to their current work, and both for that committee and this, a number of issues have been flagged up in how the means test is thought to operate in relation to abusive relationships. I think one of our concerns is that the means test as it stands has more flexibility built into it than many organisations appear to appreciate. So in the scenario that you talk about, where a woman seeking to leave an abusive relationship either isn't aware of, cannot access or cannot obtain evidence in relation to the family finances, we can make allowances for all of that. So if, for example, there is trapped capital, we can disregard that. If there are debts that have been run up by an abusive partner without the survivor's knowledge, we can take that into account in any means assessment. So that there are far more flexibilities. In terms of evidence, we can proceed to grant without seeing the normal evidence if that evidence is, in effect, in the home, and it would put somebody at risk to try and retrieve that evidence. So there are a variety of ways in which the system can and does, where we're asked, accommodate those very issues that you highlight. The issue that we flagged to the Social Justice and Social Security Committee was that quite often we're not made aware of those issues. So either a solicitor or a support organisation might advise a potential client that they won't be eligible because of how they understand the means test operates, or they won't tell us about specific aspects of the circumstances, and therefore we won't be asked to exercise that discretion, or we won't know that it's an issue at all. So I think that, as we've said at the other committee, we think we should work with the Law Society to improve awareness of how the system can actually operate in practice, so that if you like, the complexity or the perceptions of the system don't themselves act as a barrier, where in fact there are provisions to make it more accessible.
Thank you for that information, Colin. Just one last quick question. Colin, it's very worrying that you're saying that basically. We've had evidence for the last 2 weeks, and obviously the Social Justice Committee as well. If everybody doesn't know that these means tests have those levers to help those vulnerable, especially women, and I'm sure men go through this as well, but there's a lot of women that are in this case. That's why I am talking about the majority here. And you're saying that how many years on are we, and there's still awareness to be given on that, you know, means testing can help those women. And also, you know, we've got organisations that come in as well, you know, Women's Aid. So I'm just surprised, but actually very worried that this many years, this system has been in place. If anything, it needs renewing, we're talking about today. But also what we're talking about is the fact that you've just said that many of the solicitors and maybe also organisations aren't aware. And think about how many, especially, like I said, women in domestic abuse cases, survivors, are being let down by the system, because today we've just heard there's an awareness and education issue that people don't have that guidance. So, I mean, I don't know. It's just, to me, it's just surprising. You've just said something very different from what other witnesses have said. And if it's just an awareness case, why are we, you know, today taking evidence on this issue when it should have been solved and these vulnerable women shouldn't have gone through all this?
I think it's perhaps a symptom of a system which is very complex. And yeah, as I said in my opening remarks, the legal aid system is complex. There's a huge range of legislation, regulations, and guidance. You know, it's hundreds of pages of information. Many of the solicitors who do this work don't do it that regularly. So we've got this widespread network of solicitors who undertake legal aid work, and for some of them, they'll be very experienced in relation to the substantive law. So they'll be very experienced in relation to family law, financial provision, protective orders, contact, etc. But in terms of legal aid, they may have less experience. So I think this is one of the constant challenges in a system where you've got a widely dispersed provider base, many of whom do small amounts of work under legal aid, and you've got a legal aid system which is hugely complicated. So absolutely, if the system can be simplified, and the standard discretionary allowance proposal that Mary-Louise outlined is one way of simplifying that system, then that should mean that there's less room for misunderstanding. There's less of a, if you like, a burden on practitioners to learn the legal aid system, as well as practicing substantive law. And I think that would maybe help address some of the issues that we've just talked about. I just realised that I didn't touch on one of the points that you made, which is in relation to the position on housing law in England and Wales. I think the point, I think it was Shelter who made the point last week. There's a specific service in England and Wales in relation to those who are facing the loss of their home, so eviction or repossession. And it's that service which is non-means tested. So legal aid in relation to housing law is still means tested, and the means testing provisions in England and Wales are actually far tighter than our provisions are in Scotland. But that dedicated service has been put in place for that particular purpose. And I think that's maybe another example of not necessarily saying let's import the non-means tested aspect of it, but let's look at the fact that obviously in England and Wales there's been a particular problem identified which affects a particular group of people in particular circumstances, and a service has been designed to meet that need. And that's where I think the Judicare system struggles. It does not have those mechanisms for designing services and putting them in place. So I think there is a lesson to be learned there from England and Wales about the targeting of particular services for particular circumstances.
Thank you, Colin, for clarifying that. Thank you, Convener.
Thank you. Just before I bring in Marie McNair, there's been a couple of suggestions from our witnesses over the last couple of weeks while we've been doing this inquiry on ways to lessen the administrative burden on solicitors. And I just wondered if I could get your thoughts on that. One of them was removing the double audit, and another was SLAB dealing directly with third parties on payment of outlays. What's your thoughts on that?
Many and varied,
Okay.
I would say. Again, there are so many different parts of the system, and most, if not all, of the points that have been raised derive from either the primary legislation or the regulation structure, where there are particular steps that have to be taken. So the system requires there to be a limit of authorised expenditure in advice and assistance. It requires solicitors to ask for an increase in authorised expenditure before doing any further work. The regulations determine which, if any, of those kind of advance approvals can be made retrospective. And in advice and assistance, it can't be made retrospective, which I think was one of the points that was made. In many ways, again, those different measures are an inherent part of a Judicare system. And I think they're perhaps uncomfortable, but also a necessary part of a system which is demand-led. So the legal aid system is almost unique in all public services in not having a capped budget, and instead it's based on tests and thresholds and controls. And all of the topics that have been raised in evidence have been examples of the different controls that are put in place to manage the risk that is built in a demand-led budget of expenditure simply spiralling. So those controls, I think, are, as I say, they're an inherent and a necessary part of that kind of system. That doesn't mean they operate perfectly. Again, where we've got scope, we try to simplify those requirements. One example in advice and assistance is the template system for increases in authorised expenditure, where instead of saying, I've exhausted my authorised expenditure, I want to have another few meetings with the client, can I have an increase to cover that? We will instead put in place a template which will cover a case type and all the work that's typically associated with that type of case. And instead of being an increase of another £100, that might be from the outset of the case, you've got authorised expenditure of £950, £1,000 to cover the range of work that would typically be required. So we're extending those templates, extending the template for prior approval for experts, for example, again, so that we can reduce the administrative burden as far as is consistent with the proper stewardship of public funds, because that is part of our job in the system. The Act and regulations require us to do that. We want to do that in a way that is that has the minimum bureaucracy possible, that's consistent with those responsibilities, but we cannot just choose not to do those things. Okay. The point about outlays, that was a recommendation that Martin Evans made in his review in 2018. I think there were two parts to the recommendation. One was that SLAB could, if you like, use its purchasing power to construct lists of approved providers at agreed prices, and solicitors on a day-to-day basis could simply draw down on those contracts without having to seek their own experts and seek quotes for that work, because that would all be resolved in advance. We would need to change the primary legislation to enable us to do that. The other issue that Martin Evans picked up was solicitors having to wait till the end of a case to be paid the costs of those experts and other outlays, and that placed a burden on them, and if we paid direct, it would remove that burden. Since then, there have been fairly significant changes to the arrangements for reimbursement as a case progresses. The big barrier was in relation to cases where there might be a recovery where there might be money at the end of the case. Regulations have changed that in intervening years, so solicitors can now submit interim claims to cover those outlays, so they no longer have to carry those costs until the end of the case.
Okay. Thank you. We'll now move on to questions from Marie McNair, please.
Just to take you back to the discussion, obviously you spoke about that earlier, taking into account the economic impact and the financial abuse that exists. Obviously it's not widely known or used much. Is there any work ongoing just now, with violence against women partnerships or the domestic abuse charities? Because I think that would make a difference quite quickly as the awareness of it.
So we started a project a few years ago now to review all of our policies and decision-making guidance and external guidance. Where we've wanted to change our policies, we've consulted on those changes. But part of the aim of that project was to make it really, really clear and information available to people about what our policies are and the use of our discretion. How our decision makers make the decisions, and what the guidance for external purposes, so for solicitors in the main, but also others who are interested, what's the information that we would need in order to exercise that discretion. So that project is ongoing because we have around, in the legislation across all the aid types, we have around 250 types of decisions that we make. So we're going through that process to try to make what we do as transparent as possible. We also have ongoing interaction with, in particular, solicitors groups. For example, Colin mentioned the changes to templates that we want to make for immigration and asylum. So we have a good working relationship with the Immigration Practitioners Association in Scotland, which the majority of providers are part of, and we work very closely with them to consult with them on what's working, what could be improved. We're also working with the Environmental Rights Centre for Scotland, and Dr Christman was here last week to look at matters that were of interest last week at the committee in relation to environmental cases. So we're looking there to try to establish a way of trying to work out, there's proposals made, but what's the problem that people are identifying? Can we work with people to try to get down on paper and get agreement on what's the actual root problem that we're trying to solve here, and what are possibly the variety of different options that we could embark on to actually solve that problem. So changes to regulations might be one, changes to our guidance might be another, changes to actually how the services are delivered might be another. So there could be advice that we can work on, that we can provide to the government to say, actually, Judicare isn't going to work here. So there is an ongoing, I'm just giving you a couple of examples there of work that we do with groups. We also have ongoing engagement with Scottish Women's Aid and organisations like that. But in fact, before the hearing started on your inquiry, we had actually sat down with one of the staff from Scottish Women's Aid and talked through our current approach to financial eligibility, and that was a really useful restart of those conversations. And it's then about disseminating that to the different Scottish Women's Aid group across the country. So we need to work with them more to try to do that. But I think what we have seen from the evidence that's been provided is that there's more outreach that we can do, certainly. There is extensive guidance on our website, but there's more outreach that we could possibly do, so that's something that we'll have a look at this year.
Yeah, it's definitely simplifying that process where we can. It's really complex for MD, but if you're dealing with violence against women, it's the most vulnerable. It's
Absolutely.
Trying to get that access to justice, making it as simple as possible. So obviously I'm obviously in social justice as well, so we're kind of on both sides of this. But in your response to the call from views, you're doing a lot of work on the contribution levels for civil aid, and obviously the passporting for the social security benefits. Can you explain? I know you touched on that earlier on, but can you maybe explain a bit more detail? Just take your time with that one.
Yeah, so there's different arrangements for advice and assistance and civil legal aid. So if we take passporting first of all, the rollout of universal credit across the country has meant that universal credit is one of the passporting benefits. So the more people that are on universal credit, the more people are actually passported into eligibility. So that's a really important point to recognise, that if you are on one of those passporting benefits, and a lot more people are on universal credit now than were on income support, for example, in the past. But as has been pointed out, you know, the thresholds haven't changed, the levels for eligibility haven't changed for some years. I won't labour that point. We've provided advice on that. The other aspects of it are the allowances, so the policy work that we can do in terms of how we use our discretion. So there's different elements of financial eligibility that I would say that can be packaged up there as sort of separate elements. But the last point that you were making there about contributions, civil legal aid contributions is another area that, again, hasn't really changed particularly much for quite a number of years. And that's the work that we're doing right now, because it is the other side of the work that we've been doing on financial eligibility. So there's the financial eligibility side of it, but then on the other side of it is the affordability side, and that's where if you are eligible for legal aid, you can be eligible without a contribution, or you could be eligible with a contribution. Now, the vast majority of people are eligible either passported straight through or are eligible with a contribution. Without a contribution. So there's a smaller cohort of people are eligible for civil legal aid with a contribution. And we've got some discretion there, so that's what we're exploring at the moment, and happy to provide the committee with more information about that once we get a little bit further forward to look at, well, what are the possible options that we could look at to improve how the contribution system works in civil legal aid as well. So happy to come back to you about that.
No, that'd be helpful, and any kind of further information you can give to the committee in both sides, obviously social justice as well, would be really helpful.
Absolutely, yeah.
Thank you.
And we're happy to provide more information about, you know, some of those things that were perhaps misunderstandings about how the current system works. Happy to provide further clarification on those if that would be helpful to the committee.
That's me just now, but I might come back in at the end if that's okay.
Yeah,
Cheers.
perfect. Thank you. We now move on to questions from Paul O'Kane, who's joining us remotely.
It's muted.
No, we have no sound. We can't hear you, Paul. Just give us a second. Try now. No.
No.
Oh, that's it. Perfect, thanks.
You can hear me now, Convener?
Yeah,
Yes.
all good. Thank you, Paul.
Great. Okay, well, I was just saying good morning to you, Convener, and to the panel. And obviously, we've been discussing over a number of weeks, and indeed in this morning's session, around the mixed model of payments and delivery. And the discussion paper from the government indeed called for that mixed model of delivery. And I suppose there's a sense that it could address some of the issues with identifying and meeting need within the current system. But I think it would be useful to get a sense from the panel around what your feelings are in terms of both the advantages and disadvantages of that mixed model to help inform, I suppose, our work on that.
Thanks very much for that question. You're right. The mixed model is it's part of the government's discussion paper. It's something that we've been talking about for a long time, partly because I think we've observed over an extended period that the duty care system it has its strengths and its ability to, if you like, respond dynamically to situations on the ground is one of those strengths, but it is very difficult to secure services. It's very difficult to target services or to address particular needs or indeed to design those services. We've heard a lot about trauma-informed service design, and it's very difficult to see how that could be incorporated into the Judicare system, but grant funding or commissioned or contracted services could very much be designed in that way, as could the services that we deliver ourselves through, in this context, Civil Legal Assistance Office. I think some of the challenges that have been described to the committee and some of the different needs which have been expressed to the committee are examples of really issues that were never contemplated when the Judicare system was first developed in the 1950s. So although our legislation dates from 1986, in many ways it mirrors the legislation that went before that and which went before that, which is fundamentally an individual solicitor-client relationship and the legal aid system designed really as a subsidy for what is otherwise an essentially private service. So what was put in place in the post-war years and what has remained in the 75 years since has never been designed as a public service to be accessible, to be directed towards particular user needs, to be transparent, to have any guaranteed level of services, a single gateway. We say in our evidence that there are few, if any, other public services where the onus is on the recipient of the service to find somebody to provide it to them. But that is, again, an inherent feature of a Judicare system because that was what was in mind in 1950. The mixed model would seek to sit alongside and to some extent potentially replace aspects of the Judicare model. And in its place, you could have grants or contracts or commission services or directly employed solicitors operating under a different set of conditions, where the strategic decision to target resources on a particular type of problem or a client group or a geographic area means that you don't then need to separately put in place further what, to put it bluntly, are rationing mechanisms. You've made those decisions in allocating the funding, in specifying the service that you want to see delivered, and in the conditions of the grant. So we think that that may well be a model which is better suited to meeting some of the needs which have emerged and to address some of our understanding, frankly, of what good service delivery looks like in the 21st century, rather than what private client solicitor relationships looked like in the post-war years. So that's really where I think the trick would be to try and get the best balance between those two systems so that you can target resources effectively, you can secure services where they might otherwise be wanting, you can design the service to meet those needs in that trauma-informed, accessible, user-focused way, and the Judicare system could remain alongside that, either in areas of law where it seems to work quite well, adults with incapacity being an example, where we've seen massive growth over the last 20 years in take-up of legal aid in adults with incapacity. That seems to operate fairly well, but in other areas, particularly some of the more specialist areas where, to be fair, the volume of cases is always likely to be lower, and if you like, the critical mass that might be needed for an individual firm to invest in the training and to target those services might just not be there outside the biggest population centres. So that more, if you like, purposeful intervention may be more suited to those types of problems. And as I say, you wouldn't need all of the different eligibility controls or financial controls that exist in the Judicare system.
I wonder, just in terms of, because clearly what happens at the moment is people fall through the gaps very often, and what you're describing, I think, is a more comprehensive approach, perhaps, to make sure that doesn't happen. But you know, in terms of, I suppose, any disadvantages to a mixed model, do you think there are still risks around, you know, gaps in provision and perhaps the most vulnerable being able to access a service more readily?
I think whatever system you have, choices will have to be made. And this goes back to the convener's question, really, about investment. There's a finite budget for the Scottish Government. The legal aid system, as I say, is unusual that there's not a finite budget for that. But if one were making deliberate decisions to target resources in particular places, each grant, for example, would have a set amount associated with it. So ultimately, if you were wanting to have the best of both worlds, that might be a more expensive world. There are almost undoubtedly in any system compromises along the way. What the committee has heard over the last 2 weeks is about really the ways in which those compromises are implemented on a case-by-case, piece of work by piece of work, client-by-client basis. In many ways, making decisions about the scope of a grant funding programme, the overall scale of that programme, the priorities for that programme would be a more transparent way of making those choices. The accountability framework could be enhanced so that those decisions themselves could be subject to scrutiny. And that scrutiny happens once at the beginning of a programme, not 15 times every day when solicitors want to do individual pieces of work. So again, I'm not suggesting it's a panacea or it's a silver bullet or that it would magically mean that we'd be able to meet all the needs that exist in the world, but it would certainly add a major tool to the toolkit.
That's very comprehensive and very helpful. Thank you, Convener.
There's been calls to either scrap or reform Regulation 15, seen as a barrier to collective action. I was just wondering your thoughts on that or any views on the reform of it.
Yep, I'm happy to take that question. Thanks very much for the opportunity to address. I think the starting point for this is that, as we said, the Act and regulations have the controls. The controls are the other side, the balancing for the uncapped budget. One of those controls that the SLAB has to apply are the merits tests in civil legal aid. Merits test 1 is probable cause, so that just means you need to have a legal basis to your action. Set that aside, usually fairly easy to meet. The second test is reasonableness. There is no definition of reasonableness within the Act or regulations. SLAB over the decades has developed policy and guidance on how we apply that discretion, how we apply that test. One of the factors that we take into consideration is wider public interest, and I think I heard from witnesses last week, and there's specific guidance on how we apply that, and that we do take that into consideration. We recognise that in some instances, if I can just quote from it, individual cases can aid strategic development of the law for groups, including groups protected under the law. If it can be demonstrated when the outcome of the case may have a direct tangible benefit to your client and to others, then the reasonableness test would be met. So when we're considering wider public interest, Regulation 15 will gain information and knowledge from what the solicitor puts to us under that test, that we can then consider Regulation 15. And Regulation 15 has been there since into the 1950s. That was where it first originated, and it's one of the additional controls. So the aim of it is, I think, is to control expenditure, and indeed the government did consult on it in 2016 in relation to environmental cases, and it was about the risk of the gates opening and it being a risk to the uncapped budget. In terms of how we apply it, I can say that it has come into our decision making, but we have granted on several occasions, and I can just give the committee hopefully a couple of examples over the last couple of years. So in Glasgow, the Wynford Road demolition of those flats, we granted legal aid for the action that was being taken to challenge that decision. In Torry in Aberdeen, the redevelopment of a recreational park as part of a sustainable energy strategy and part of the local authority. In Murray, Slochy Woods challenging RIA housing development decision. The winter fuel allowance decision by Scottish ministers, we granted legal aid for that challenge that was made, that very high profile case. Closure of the public library in Ballach, closure of Kirkton Community Centre and Library, closure of the swimming pool in Auchinleck. These are just some of the examples where we have granted legal aid for individuals to take forward a challenge to those decisions that are being made in their local communities. So we did consider Regulation 15 within those cases. So if the person can show that there would be serious prejudice to them, then the first part of the test is met. We can be satisfied, therefore, that the application should be granted. The second part of the test, we can look at that. It is a very difficult regulation. There's no two ways about that. We don't think that it's a simple thing for people to understand. It's not simple for us to apply and explain either. The second part of the test, we can see from the information that's provided to us that in a lot of cases it never really applies, because there isn't a set group of people, an identified, defined group of people to whom that test applies. And it's very rare that they would be people of abundant means. So that second part of the test, it never really comes up that we can see a defined group of people who have abundant means. So it's not something that we need to go into great detail about with most solicitors. I can only recall one case in the last sort of 15 years where there has been a very, very small group of people. I don't think our position is that it could be improved. It could be. But I think what I'd like to give the assurance to the committee about is that we do apply it and we do grant legal aid because we can be satisfied. I think the work that we're doing with Environmental Rights Centre, one of those items of work is to look at people's understanding of how high a bar they think that test is, and for us it's not as high a bar as people have interpreted it to be. So we can work with them on our guidance. That's one of the pieces of work that we're doing at the moment with Environmental Rights Centre, is to look at our guidance on this to try to help solicitors to understand. Second part is that we will review our policies and decision makers' guidance on this as well. That'll take us a little bit longer. And the third element of that work that we're doing with them, as I mentioned already, is to provide advice in the government on what are the options to resolve the problem, which is actually about how do people get access to representation to take their cases forward. People's aim isn't obviously to get legal aid. People's aim is to solve their problem within the current justice system that we have. And way of resolving problems that we have. Obviously, people have talked in previous panels about improvements that could be made to how people resolve their problems in different ways that are not about forcing people through the court system.
Again, if I can come in,
Thank you. Yeah.
I think it's another really good example of something that challenges a model which is based on that individual solicitor and client. So we've talked about strategic litigation where a wider group of people may benefit. You've heard about legal aid for groups themselves, where the group takes forward the action. So group proceedings, and obviously there are court procedures for financial claims on that front, and also for organisations to be able to take forward challenges. None of those were the things the legal aid system was designed to address. And it may be that rather than see how we can bend the legal aid system to accommodate those different kinds of demands, we could maybe think about, are there different solutions to those problems? The legal aid system, the Judicare system, cannot be all things to all people. That doesn't mean that publicly funded legal assistance cannot be available for those things. And that goes back to Mr O'Kane's question about that mixed model.
Thank you. That's very helpful. We now have questions from Tess White, please.
Thank you, Convener. My question, I've got two questions to Mr Lancaster. So we've heard that finding a solicitor to help with most vulnerable people who are most vulnerable in domestic abuse cases, particularly when they're experiencing financial abuse, is almost like trying to find hen's teeth. That women, especially, have looked at 100 solicitors or approached 100 solicitors to find help. Are you concerned about this?
I think obviously some of the situations have been designed to that have been described to the committee are we have a great deal of sympathy with people in that position, people who are facing those other challenges in their lives and who are either seeking to protect themselves or their children or rebuild a life away from an abusive relationship. Legal aid should not be part of their problem, and finding a solicitor should not be part of their problem. But as I said in relation to some of the other questions, the mechanism to secure that service doesn't really exist in the legal aid system. We do have people who call us who are looking for solicitors. We don't always know whether they're successful, because if they are successful, they won't come back and tell us that, and rightly so. They're getting on with building the relationship with a solicitor. We have consistently over a number of years had discussions with Scottish Women's Aid around this issue, particularly in relation to domestic abuse, which is obviously the topic of your question. As a result of those discussions, we agreed to put in place a system with our Civil Legal Assistance Office, where we would, if you like, gather details from Women's Aid Services about the problems that people are experiencing, as in the problem they're trying to solve, their legal problem, and we would seek to refer them to a solicitor. And that's given us a better sense of, if you like, the scale of the issue. And in its first year of operation, we received around 200 referrals. It's also given us a better insight into the range of legal problems that people are facing there. And protective orders themselves are quite a small minority of those 200 referrals. Most of those cases relate to general family matters, so divorce, separation, care of children, financial provision. And in 2/3 of those cases, we were able to successfully refer the client to a solicitor. That does leave a gap, clearly, but we now have a better sense of where that gap is. And that all helps build a picture of the type of intervention that might then be needed. So what that suggests is we've got a sense of scale, nature and distribution of the problem, and that can then help inform further decisions around the service that we provide. And one of the things we're considering at the moment is extending that referral service to other areas of law. So not just exclusively in relation to domestic abuse, working with other partners, not exclusively Scottish Women's Aid, but also what that says about the service we should be providing through the Civil Legal Assistance Office, whether we don't tend to do this type of work, but whether we should be doing this type of work, or whether there are parts of the country where a more proactive funding solution ought to be put in place. Again, that's not at our hand. We can't simply decide to allocate a grant. There's a whole process, again, built into the legislation about their approvals and the construction of grant programmes that we'd have to go through. But we've now got that better understanding, as I say, of what the issue is.
I suppose my question, you didn't really answer the question, it was, are you personally concerned about this?
Well, to the extent that people aren't able to access a service which they need, yes, that is of definite concern. But there's a difference between me being personally concerned about it and me having the power to do anything about it. And I think that's where the challenge comes in many of these questions. We can observe, we can understand problems, but the system as it stands gives precious few opportunities to actually act upon those concerns or respond to those challenges. And that's why we've consistently called for, and we're really pleased to see it reflected in the government's paper, that idea of that mixed model, where rather than studying problems, we're able to then go out and try and solve those problems. And the Judicare system does not have the levers to enable those problems to be solved.
Thank you. And my second question is around almost the pool of solicitors, and there seems to be a systemic problem that there aren't enough solicitors to do the work. So in the 9 years that you've been Chief Executive, have you sat down with the Law Society to discuss this systemic issue of the pool of solicitors?
Yes, we have. We've discussed that regularly. Again, part of the challenge is understanding the nature of the problem, the scale of the problem, and then working out what can be done about it. As I said in relation to Ms Tweed's question, there is no mechanism for planning a workforce here. It's not like other public services. It's not like dentistry or GP services or midwifery, where if there is a shortage, you can put plans in place to train and recruit and retain a workforce. Those are not things over which we have any control, and in fact we have precious little influence over those things, because, as I described at the outset, the shape and size and focus of the judiciary legal aid system is determined by the choices that individual solicitors make on a day-to-day basis up and down the country. Now, hundreds of those solicitors make the choice to provide legal aid services in thousands of cases each year. So there is a widespread network of solicitors doing that work. What we don't know is when people phone 20 or 30 solicitors, is that because nobody has capacity until they find somebody who does, or is it because they don't know who provides a relevant service? If you're phoning criminal firms or commercial firms when you've got a domestic abuse problem, you're not going to get access to the service. But there is no identifiable clear gateway into the system because it's not designed with the user in mind in the way that other public services are.
I would suggest to you, you have more power and influence than you think you have, and to sit down with the Law Society and talk to them about the pool of solicitors and influence the universities. We had one example a few weeks ago where there was a system that happened during COVID where trainee solicitors, places were provided for early entry solicitors into the profession to actually undertake work such as this, but that seems to have dried up, and I almost feel as though you've given up to say it's not with me, I can't do anything about it, whereas you actually can do something about it, and something that is so broken, the overly complex system, not enough solicitors, and it's not just 30. We're hearing of women who have experienced domestic abuse. They're homeless, they've suffered financial abuse, and they've got nowhere to go. So if it is so bad, which it seems to be, because we're hearing evidence, what's to stop you sitting down with the Law Society and looking at the number of solicitors being trained? Does it need to be increased? What are the solicitors going into? How many of them are doing legal aid? Should we provide certain funded positions for like was done in COVID? So I put it back to you that maybe to sit down with the Law Society and work out some solution and have some ideas might be a way forwards.
No, and as I said at the outset, we have regular discussions with the Society. We've had those regular discussions over a number of years. Again, as I explained in my response to Ms Tweed's question, many of the issues that have emerged from those discussions are not legal aid specific problems, and therefore legal aid specific solutions are unlikely to address some of those wider underlying issues in terms of the shape, size, structure and focus of the legal profession and the career aspirations and ambitions of young lawyers. We do go out to universities. We do our internship work, as I mentioned earlier. We are taking on trainees to bring people into this area of work, but that really is about the limit of what we can do. The traineeship scheme that you refer to was not a SLAB scheme. That was a Scottish Government-funded scheme run by the Law Society of Scotland. It's not in SLAB's gift to do that work. Or to provide that funding, or to institute those sorts of schemes. I'm absolutely not giving up on this because these issues have been around for a long time, and we have consistently pursued reform to the system specifically to enable us to do more work in that kind of field, to be more strategic, more proactive, more focused on solving the kinds of problems that have been presented to the committee. That's not the system we have. Those are not the powers or functions or resources that SLAB has.
Thank you. Back to you, convener.
Thank you very much. That brings a close to our question session with our first panel this morning. Just making sure that all members have been able to ask everything that they wish to do so. Yeah. Marie?
Just to ask, you know, what kind of further changes you could make without the need for regulations? Is there anything else that you could do? You know, the simple fixes, or have you addressed them already in your contributions?
I think most of what we can do, we've talked about. The government's paper sets out a number of regulation changes, which can obviously be brought forward more quickly than primary legislative changes. The process that Marie-Louise described of consulting on our policies and examining all the ways in which we apply our discretion. Each of the changes that we make might make the system a bit more easily understood, a bit clearer to providers and to applicants. It could take some of the rough edges off, and it's absolutely worth putting the time and effort into taking those rough edges off, but it's not going to address the fundamental issue that we've been describing this morning.
Okay, thank you.
Thank you. That brings our first panel to a close. We will now suspend briefly to hand over to our next panel. Thank you. Thank you so much. I would now like to welcome our second panel of witnesses today, Siobhan Brown, Minister for Victims and Community Safety. And Ms Brown is joined today by Scottish Government officials. We have Martin Brown, Solicitor, Legal Directorate, Simon Stockwell, Family Law Unit Head, and Susan Young, Access to Justice Unit Head. You're all very welcome this morning. I'd firstly like to invite the Minister to make an opening statement.
Thank you, and good morning, Convener, and good morning, Committee. Convener, I am grateful to the Committee for inviting me here to contribute to your considerations on civil legal aid. I recently took the opportunity and met with staff from grant-funded projects and heard firsthand about the excellent work, services that they deliver to people across Scotland. But in saying that, many of the issues that have been raised with the committee are similar to the discussions that I have had about the need for change. This government recognises that reform of the current system is needed and that there are challenges in certain areas within certain types of legal aid work. The recently published Legal Aid Reform Discussion Paper sets out a programme of work for the rest of 25 to 26, and our first priority is to engage with stakeholders on draft regulations and the associated impact assessments. These changes will make it easier for both solicitors to work with legal aid funding and for those who need legal assistance to access it. We will reinitiate a fee review planning and collaborate with stakeholders on the reform of legal fees in 2025. We will take the same collaborative approach to developing detailed proposals for future primary legislation, working with SLAB, private and the third sector stakeholders to explore areas of diversifying funding methods and embedding users' voices, something which has been called on by those responding to the committee's inquiry. The independent strategic review of legal aid carried out noted that Scotland is one of the leading jurisdictions in Europe in the provision of legal aid, judged by scope, eligibility and expenditure per capita. In almost all solemn criminal cases, the accused will get legal aid, and in civil cases, the scope of legal aid is broader in Scotland than in very many other jurisdictions, with comparatively little excluded. Legal aid doesn't sit in isolation, though, and it is an essential component of access to justice. We recognise that legal aid plays a crucial role in upholding the principle of equality before the law, ensuring that those who cannot afford legal representation are not disadvantaged in the justice system. Legal aid funding allows solicitors to deliver their services to people remotely as well as in person, supporting many people with civil problems. We have maintained the scope and resourcing of legal aid, and the demand-led budget means all eligible costs are met. This means legal aid expenditure is likely to reach £174 million in 2025 to 2026, which is an increase of £5 million on last year's expenditure budget figure. This will be the highest ever level, highlighting a trend of increasing levels every year. And we must ensure that delivering legal aid is fair to those that deliver the services and to also be effective, efficient and deliver value to the public purse. We have also maintained funding of the Scottish Legal Aid Board's civil legal advice grant-funded projects up to £2.3 million this year. Convener, I am aware of the significant input the committee has already received in aid of this inquiry, and it is clear from all the submissions received and the evidence from the panel sessions there is a strong feeling that civil legal aid in Scotland needs reform, which is also the belief of myself and the Scottish Government, and I am happy to take any further questions, Convener. Thank you.
Thank you very much. We'll now move on to questions, and I'm going to kick us off here. There has been a priority. One of the key asks from our witnesses so far has been for a significant increase in funding. What resources are available to support these reforms?
So thank you, Convener, for that question. We have to remember that legal aid fund is demand-led and directly linked to application numbers, and all eligible costs are met. As I said in my opening statement, I think this year alone there'll be £174 million. In relation to the reform, where we're drafting SSIs at the moment, we are putting them out to consultation and looking at the assessments of those as well. When I met with SLAB last week, these kind of SSIs could take up to 4 to 8 months to be implemented. So by then we will be able to implement them and there will be a budget available for them.
That's great, thank you. The committee has repeatedly heard from witnesses that the current fee rates and rules prevent legal aid solicitors from being able to take the time to work with clients in a trauma-informed way. Will the Scottish Government work with SLAB to ensure rules are changed to support trauma-informed working practices?
Yes, absolutely, and I think this is part. I think we all recognise that reform is needed in legal aid, civil, criminal, or across the whole board. And I think one of the main important issues is that to be more trauma informed, and I'm more than willing to work with SLAB and any third sector organisations to ensure that this happens in any legal aid reform moving forward.
Okay, thank you. We'll now move on to questions from Evelyn Tweed, please.
Thanks, Convener, and good morning, Minister and panel. My question is around recruitment and retention. And Minister, you will have heard that we've heard quite a lot from witnesses. There are a lot of anxieties around this area. The Scottish Government did fund legal aid traineeships in 2021. Has there been an evaluation of this, and is this something that's going to be continued in the future?
Yes, one of the things is recruitment and retention is an issue that has been raised with me since I've been in this role. I'm sure the committee will know about the future legal profession working group, which is looking at the short, medium and long term. The traineeship fund that was announced for 40 traineeships was welcomed by everybody. Everybody really welcomed that. We are in the process of going through the evaluation that we have received just recently from the Law Society of Scotland, and we will be looking at how it can be rolled out, something that I'm keen to progress with.
Do you know when the evaluation is going to be completed?
I think I don't know if anyone's got a timescale for it.
Hopefully within the next couple of months or so, and we'll provide advice to the Minister on that.
Okay. That's fine.
Thank you. We now have questions from Pam Gossel, please.
Thank you, Convener. Good morning, Minister, and good morning, panel. My questions are a little bit long because I've been kind of pulling things together for the last 2 weeks on our witnesses, so please do ask me to repeat anything that after I've asked my question. Witnesses from the last 2 weeks have called for financial eligibility criteria to be expanded, as financial thresholds have not been updated in line with inflation since 2011. Minister, that's 14 years ago, nearly a decade and a half ago. To give you some examples from some of the witnesses we heard from, were saying that these outdated financial thresholds are not fit for purpose in this decade. Andy Sorrell from Just Right said, if you have £1,718 in your bank account, you are not getting legal aid. Today we also heard concerns on this from Colin Lancaster from Scottish Legal Aid Board. Last week, Dr Ben Chrisman from the Environmental Rights Centre for Scotland said that someone over the age of 21 on a national minimum wage working more than 20 hours per week isn't eligible for advice and assistance, as the currently weekly disposable income threshold is £245 per week. He even referred to scenarios of people in receipt of universal credit who are not eligible for advice and assistance, just like today, obviously, Colin Lancaster also said. Yet some cases can cost up to £500,000. If someone on universal credit can't get legal aid, who is legal aid for then? If we can't even help those people that most need it in our society, could you clarify who we are actually helping, Minister?
Thank you for that question. Just if I could, just on the point of financial eligibility thresholds for civil A&A and civil legal aid, I know this is something that I discussed briefly with the SLAB board when I met with them last week. And SLAB have provided an analysis paper to the Scottish Government that advises on a range of possible changes to financial eligibility thresholds for civil legal aid and advice and assistance. And the modelling includes their impact on eligibility levels and costs. But any changes of any policy, this will not be cost neutral. So it's something that we will have to, obviously, as a government, consider. We will carefully consider this paper in conjunction with the wider set of reforms set out in the discussion paper. And just to go back to your second point, Ms Gossel, regarding who's receiving legal aid, I've sat here and I've over the last couple of years and spoken to the legal profession, and I totally appreciate and understand the challenges that they are facing. And I think, as I said, we really do need this legal aid reform moving forward. As a government, we have seen legal aid budget go up every single year. I think 2 years ago it was quoted at £141 million and it went up to 151. And because it's demand-led, the Scottish Government will pay it. We're now up to 174. So every year we're seeing an increase in legal aid. So it's not that people are not getting legal aid. It's being increased every year. But I think this is where it's been highlighted to the committee. It's so complex to understand, but we see it from the SLAB side. I'm seeing it from the Scottish Government side, the budget every year increasing, and this is how we have to work together with the legal profession, with SLAB and with all the third-party sectors on how, moving forward, we can create a model that addresses all the challenges that everybody currently faces. But there are people getting legal aid at the moment just due to the budget, and I don't know if there's anybody else that wants to comment. No? Oh, Martin, sorry.
I don't know the details of the example that you raised in relation to universal credit. All I can say that it is a passported benefit in terms of income. I suppose it's possible that if someone had capital that took them over the threshold, then they wouldn't be eligible for civil legal aid. But on a sort of standard setup, you'd expect a person on universal credit to get civil legal aid.
No, thank you. And it's something please do look at in your reform, that obviously, because this has been now the last 2 weeks it's been brought up, that if people basically have that little amount of money, then they're not, they don't get that advice and assistance. Do look at that, Minister. My next question, Minister, over the weeks we've taken evidence in this committee with regards to how legal aid is administered for survivors of domestic abuse. Andy Cyril from Just Right 2 weeks ago highlighted that sometimes a survivor of domestic abuse can go to 30 to 50 law firms before they can get a solicitor. If these figures are not horrendous enough, we also heard a woman who was attacked by her husband in her divorce case contacted 116 firms. Last week, Marsha Scott from Scottish Women's Aid said that we are no closer to reform now than we were in 2017. She also said that the current model is not fit for purpose as it chops lives into little bits. The livelihoods of these women, and in many cases the livelihoods of their children, are at stake. The situation is so bad that even the United Nations Human Rights Committee pointed out that are concerned about the depletion of legal aid lawyers across the United Kingdom, but particularly here in Scotland. Minister, as you'll probably be very aware, for the survivors to even take that first step to contact a solicitor is a big step. We know that many survivors even don't do that. But Minister, we're talking about 116 firms. Just imagine picking the phone up for that survivor. I need help once, twice, 3 times, 116 times. Minister, this isn't good enough. And as Minister for Victims and Community Safety, and also from the Scottish Government, we cannot keep dragging our feet with this. It's so important that these women are treated with dignity and respect, and that I'm really hoping that the reform you've mentioned today that takes all this into consideration, because this is on the ground. And as you know, with my Prevention of Domestic Abuse Scotland bill going through, I've had the opportunity to speak to many survivors, and this is a big issue.
And I totally appreciate your comments, Ms Gossel, and it's unacceptable. As we know, people fleeing domestic abuse, they can be some of the most vulnerable in our society. I am pleased, though, because of the regulation of legal services last week that was passed in Parliament. This will remove restrictions preventing charities, law centres and citizens' advice bodies from directly employing solicitors to provide certain legal services to some of our most vulnerable, including those fleeing domestic abuse. And watching the evidence of Marcia Scott, this is one of the things that she highlighted, because you might get someone who might take on a case for domestic abuse, but then they won't take on the other issues that they might need legal assistance with. And this is where the regulation of legal services that was passed last week, this will make things a lot easier, just specifically for people fleeing domestic abuse there. But I do take your comments on board, and this is why no one's disagreeing that we don't need reform in legal aid, and all these issues will be embedded in the heart of how we move forward.
No, thank you, Minister. Just one last thing that obviously we heard from Colin Lancaster earlier on, and he mentioned that sometimes there are levers there to help those survivors out there. However, especially when it comes to eligibility that we spoke about earlier on, but I think there's a gap here which is actually quite worrying, and I said that earlier on about awareness, that solicitors aren't fully aware what the legal aid has to offer, but also organisations don't. And one of the committee members obviously did touch on that, earlier on, to say that what sort of work's being done to basically make sure that the actual law right now that's in place, and we know it's very complex, we know that it could be simplified, but how are people not getting that information, whether it's lawyers and organisations? And we've come this far in that many years, and there's a big issue that wasn't identified years and years ago, that's where it's very shocking that we've let this go on when a lot of vulnerable victims could have actually had that help that's needed. And obviously, you heard Colin speak about that the system doesn't allow them to actually action any of this work, so that they need more. And my colleague Tess did point out there was a lot more work that they could do with the Law Society. So I just wanted to ask you something around this awareness, but also why did it take this long for this to be identified, and how can we move forward? I know that you're doing the reform, but it's going to take time. But how can we move forward to help those vulnerable victims now?
Yes, so the reform paper, the discussion paper that's just been published, and we're working on the SSIs at the moment, the draft regulations, that's looking at short-term things, right? I know that before we're going to PERT, we've got 9 months, so it's limited on what we can do, but we've got the ball rolling on certain things there. But it also looks at what we can do medium to long term. I appreciate your comments that there are avenues for people that are fleeing domestic abuse that SLAB could make exceptions for. And I was listening to the evidence session, obviously, before I was coming in here, and as Colin had said, it's very complex, and maybe some of the lawyers just aren't aware of it because it's not maybe a specialised field that they take a specific interest in, and then they may one day just take up but not know about everything that might be available. So I do think there is, moving forward, and should maybe be in place now, but moving forward as we do with these legal aid reforms, that specifically working with the Law Society and all the stakeholders to ensure that any solicitors that are dealing with specific case, be it domestic abuse, criminal, whatever it is, and there's something specific, and there could be some criteria that SLAB could make exceptions, that we have to ensure that the legal profession are aware of those.
Thank you very much, Minister. Thank you, Convener.
Okay, thank you. Minister, there has been calls for Regulation 15 to be reformed due to instances where witnesses have stated it could cause a barrier to collective action. To help people realise their rights with legislation that the Scottish Government has passed in terms of environmental and human rights, does the Scottish Government have any plans to reform Regulation 15 of the Civil Legal Aid Act?
Thank you, Convener, for that. And if I may, I think if I can just state that it is important to recognise that there are different standards in terms of the ECHR for criminal and civil legal aid. So Article 63C of the ECHR provides for the right to a fair trial, and where a person has insufficient means to pay for legal assistance, it is to be given free when justice so requires it. And there's no equivalent mechanism or right for civil legal aid. Just in relation to Regulation 15 that Convener highlights, I know that the SLAB have been engaging directly with the Environmental Rights Centre for Scotland earlier this year, specifically on Regulation 15, and they have provided an initial briefing on their approach to Regulation 15 and also a meeting with ERCS to discuss. So their intention is to use this engagement to establish evidence of the position from their respective perspectives and better understand the potential problem. This work is ongoing with the aim of delivering advice to the Scottish Government on recommendation options. So there is work ongoing in the background, and we will address that when we get our recommendations.
Okay, thank you. We now have questions from Paul O'Kane, who's joining us remotely.
Thank you very much, Convener. I'm just going to double check that you can hear me in the committee room.
Yeah, perfect. Thank you, Paul.
Perfect. Good morning to the Minister and to officials. Obviously, in the previous session and throughout inquiry, we've been looking at the mixed model as proposed within the government's discussion paper. I suppose we had a bit of a discussion in the previous panel around the finance and around the money that is put into legal aid by the government. I mean, is it your view, Minister, that a mixed model would actually save money?
Thank you, Mr. O'Kane, for that. I think moving forward, I don't think it's to save money in the mixed model. I think moving forward with the reform, there has to be a balance and flexibility between both models. Obviously, we need the duty care moving forward. We always will need that. But if we can also move forward with grant funding, and as we move forward, the Scottish Government's aim to be able to give more than year-to-year funding, then that's the way we're moving forward, to sort of have a balance and flexibility of both. But it's not specifically to save money.
Okay. Obviously, there are concerns about the amount of money generally in the system and the risk, I suppose, that with any model, people fall through the cracks. So I wonder if you might say something about what the government's doing in terms of trying to ensure sufficiency of funding, and I take the point about trying to move to multi-year settlements. But, you know, what is the government particularly looking at in ensuring that people don't fall through the cracks in any mixed model?
Thank you. Thank you, Mr. O'Kane, for that. I think this is part of the recommendations that we will consider moving forward with the wider reform. I don't know if there's anything, Simon, you want to add about that, or Susan?
There's official level discussions going on at the minute for people, as you say, that might fall through the cracks, and we'll be looking at that as we go forward with reform as well. Reform gives us the opportunity to look at the unmet need, if you want to call it that.
If I may, can I just come back to Mr. O'Kane, just on the issue of funding, because it's something that I think is important to highlight. I know that the legal profession feels that people are leaving the legal profession because of underinvestment, and I recognise historically there hasn't been regular uplifts for fees, but from 2019 there has been a 25% increase from the Scottish Government specifically as an uplift to the legal profession to try and solve some of the challenges that they have faced. And this has been, I think, up 25%, so that's above the inflationary rate since 2019. From that, and this is why another reason why we need reform, we haven't seen a significant increase in solicitors, and I think it was £31 million that's been put in since 2021. It hasn't made much of a difference, and this is where we really need to look at all the different models to see, especially for the public purse, where this money is going and how we can ensure that it is delivering for vulnerable people and the people that need it.
Well, obviously, funding is one part of reform, but we know that there's larger issues, and there are issues that are short-term and there are issues that appear to be longer-term in terms of particularly things that might require legislation. Do you understand the frustrations that people have around the time that this has taken and will take? I mean, I appreciate there are things that we need to get right, but I think there's a degree of frustration we've heard throughout evidence about the slow pace and not achieving as much as we would have hoped, I think, in this session of Parliament.
Yes, Absolutely. Yes, I do appreciate the frustrations. I think just if I could sort of just give a bit of clarity on the background, obviously I think my predecessor invited Martin Evans to do the independent review, and the Scottish Government published its response back in November 2018. We then went into the COVID era, so things were delayed. There has been substantial progress on things which were recommended in the Evans review, such as the Legal Aid Remuneration Project and Research Analysis Group, where there was extensive work which was carried out to agree the scope of potential research, and that this work is ongoing. So I did see Pat Tom from the Law Society, and I know that Mr O'Kane did speak to her about the history of that. There was £10 million given, for example, on the understanding that everyone would be on that board, and a lot of work did go forward with that remuneration. I think maybe one of these things, even though we haven't made progress moving forward on primary legislation, which we will do in the next parliamentary term, is I really think one of the things that we need to appreciate and to get sorted is the funding model. This board, we did put it out to tender twice, and unfortunately we weren't able to get anybody to look into it. But I think moving forward, historically, because there haven't been uplift, and I appreciate we have uplifted it in the last 5 years, 25%, but before then it wasn't done as much. Moving forward, I think we need to be have stability for the legal profession on some funding mechanism annually that it can be reviewed. So I think this is a core part of legal aid reform on how we move forward, because I think it's a bit disjointed. There's a lot of issues. It's very complex, but until we get this primarily sorted, I don't see how we can progress moving forward. Although there is will to, I want to move forward with the legal aid reform.
Yeah, and the Law Society obviously gave evidence in terms of their frustrations, but also the opportunity that they saw in terms of where we are now, and certainly the things are beginning to move. So they were hopeful that there would be certain proposals, I think they described them as tweaks to the system, that might be implemented in the summer before the end of the parliamentary session. I mean, is that something that you are working towards?
Yes, we are. We are looking at some draft SSIs. I think it's going to be after the summer at the moment, but we are doing what we can with the secondary legislation to work at pace at what we can do in the meantime before we go into PERDA next year.
Okay. And committee, we keen to follow up. I'm very grateful, Convener.
Okay, thank you. We now have questions from Marie McNair, please.
Thank you, Convener. Good morning, Minister and officials. I'm going to repeat the message in terms of the multi-year funding. It's something we've heard over the last few weeks, from previous recipients that grant funding is a huge significant issue, connecting to the funding streams, and there's been calls for multi-year funding, but also calls, for earlier fit funding announcements as well, so that they can plan ahead and strengthen their services. So I'm heartened to hear that you are looking at the multi-year funding. How else can we, sort of be better addressed going forward? How can we better address this?
Absolutely, and I know the frustration. I can appreciate it. It's brought up with me quite frequently, how organisations just go from a year-to-year funding model. You'll appreciate the Scottish Government does the same. We don't know what we're going to get to September, October the year before we can finalise our budget moving forward. But I know that we recognise the financial uncertainty, and I know this is something the Scottish Government's aiming to move away from the short-term projects. And I think that it is part of the 25 to 26 programme for government. The Scottish Government has committed to delivering a fairer funding pilot, and that provides multi-year funding to third sector organisations that deliver frontline services and tackle child poverty. It's not every organisation, it's just a pilot, but I'm hopeful moving forward that this is a success, and then we can move forward into other organisations getting multi-year funding as well.
I certainly welcome that commitment, and we'll keep pressure on you. Thank you.
Thank you. Thank you. That brings us to the end of our question session. Can I ask if members are content that they've asked everything that they wish to? Yeah, they have. Well, thank you so much for joining us this morning.
Thank you very much.
That concludes our business in our formal session, and we will now close and move into private session to consider the remaining items on our agenda. Thank you.
Thank you.